So now we're live. Thank you very much for this panel. This panel is So this panel is a panel about COVID and the impact of COVID in competition law. And this is the last thematic panel of this conference. We're going to have more lectures, and tomorrow we're going to have more presentations from students. But this is the last thematic panel. I'm going to say that it has been 3 days of work, but wonderful days, a wonderful ride here with IBCI to host and to moderate some panels and to discuss competition law. And it's a pleasure to end these thematic panels with a panel about COVID. And we have 4 experts here in competition law. I'm going to present all of them first. The first one I'm going to present is Penelope. Penelope is from the University of Portsmouth, UK. And she has published work about COVID and about public procurement also. I know she's an expert on that too. We're going to have Commissioner Barreto. Commissioner Barreto is a commissioner at CADE. It's Brazilian Authority of Competition Law. And he is also a professor at FGV. And he made his master and his PhD from Chicago University. We're going to have also Maria Fernanda. Madi has a PhD in law at Erasmus University of Rotterdam with focus on competition law. And she is a Brazilian EU qualified lawyer and author of books and papers in the area of competition law. And we're going to have also Professor Luiz Estevez. Professor Luiz Estevez is the chief economist at Banco of Nordeste, visiting researcher at IPEA. It's the Institute of Applied Economic Research from Brazil. Visiting researcher at Queen Mary School of Business, University of London. And he is a colleague of mine at Paraná Federal University in the economics department. So let's start with hearing from you, Penelope. You can share your screen and the word is yours.
Thank you so much. Please give me 2 seconds to share with you my slides. Please let me know if you're able now to see my slides.
Yes, you can see.
Excellent. So first of all, thank you so much for your kind invitation. It's a great pleasure to be here with you today in order to discuss and critically analyze the phenomenon of price gouging in the time of coronavirus. So we all know that the alarming spread and severity of COVID-19 have resulted in an apparent price gouging on many products in high demand, such as hand sanitizers, disinfectants, and face masks. What is price gouging? Price gouging is when businesses heavily inflate prices of products in high demand. These prices have no reasonable relation to the economic value of the product supplied, and so this has a hugely negative impact on the consumer. European antitrust enforcers don't easily proceed against excessive prices unless there is clear violation of Articles 101 and 102 of the Treaty on the Functioning of the European Union. And this is because price controls are one of the most intrusive forms of intervention in the market, and they are heavily criticized in Europe. So my presentation today does not regard Article 101 of the treaty, nor collusive price gouging. Today, I'm focusing on Article 102 of the treaty, the provision that tackles excessive pricing when price gouging is generally unilateral. Unilateral price gouging may result from an abnormal level of demand. For instance, when we have more and more consumers wanting to buy the products due to an emergency. Under such circumstances, many companies, and not only one that may be dominant in the market, usually set excessive prices of these goods and services because they are in high demand. This is what happened exactly in the COVID-19 pandemic, as many sellers raised prices on essential hygiene and medical items in high demand. So in my presentation today, I'm going to discuss Article 102, Section A of the treaty. This is the provision, as already said, that the national competition authorities in Europe and the European Commission can enforce to ensure that consumers are not paying inflated prices during the coronavirus crisis. In this context, I'm also going to explain the practical and conceptual difficulties that excessive pricing cases involve, especially under the urgent circumstances that coronavirus has caused. Then I'm going to assess the remedies as well as the provisional remedies that can be imposed to tackle price gouging, and I'm going to make some recommendations. Finally, yet importantly, I'm going to examine if it is preferable for the EU member states in terms of flexibility and promptness to rely on price regulation, which is an inherently political activity. France is an illustrative example because it imposed a ceiling on the retail price of hand sanitizers, but also on the wholesale price to third-party merchants after the coronavirus outbreak. As I have already mentioned, national competition authorities and the European Commission show an interest in pursuing excessive pricing cases only when such activity violates the discrete prohibitions of Articles 101 and 102 of the treaty. Article 102 condemns unfair purchase or selling prices that an individually dominant firm sets. Yet, what happens if the excessive prices on goods and services in high demand are not only set by the dominant company in the market, but also by other companies as well? For this kind of case, Article 102 of the treaty prohibits the abuse of dominant position by one or more undertakings. According to Article 102 of the treaty, imposing unfair purchase or selling prices may constitute abuse of dominant position, which undertakings in the market can hold either individually or collectively, and I'm underlining these. This is the provision that has been used so far to prohibit excessive prices. So based on this provision, if more than one undertaking charges excessively high prices, they can be held guilty of abusing their collective dominant position in the market. What strikes someone's attention is that there have been only few investigations of excessive prices under Article 102. So let us try to understand why this is the case. The first difficulty that the European Commission and the national competition authorities will have to face if they want to rely on abuse of excessive pricing to fight price hikes is to assess whether the companies concerned are dominant or not. In order to do so, it is necessary to define the relevant product and geographic markets and then examine if each company on the market enjoys a position of dominance. If a company has a market share of less than 40%, it is unlikely to be dominant. The 40% market share threshold makes it quite difficult for national competition authorities to intervene with excessive pricing in the time of coronavirus, because the sellers of goods in high demand due to COVID-19 are not necessarily big businesses, and they do not have a position of dominance in the market. A possible way to deal with this issue is to look for transitory market power and not for a traditional dominant market position that requires a market share more than 40%. The concept of transitory market power was firstly used in the European Commission's decision in ABG oil case. In that case, it was held that it is possible for more than one firms to hold a dominant position relative to their customers if the customers become completely dependent on them for the supply of scarce products. Although on appeal, the above decision of the European Commission was annulled, the Court of Justice did not challenge the question of dominance. So this enables national competition authorities to follow perhaps the same line of reasoning as the European Commission in ABG oil decision and try to establish transitory market power for the sellers of goods in high demand due to COVID-19. The second practical hurdle that the European Commission and the national competition authorities may face is the assessment standards of excessive prices. For the determination of excessive pricing, there is a twofold cost-based test that should be taken. The first limb of the test regards comparison of the selling price of the product or service with the production costs. The second part of the test regards geographic price comparison or comparison of prices over time. Both requirements should be met cumulatively in order to establish excessive pricing. Regarding the first limb of the test, it is not easy to calculate the difference between the production cost and the price of the product or service in order to identify the profit that dominant firms earn. And this is because the calculation of the difference requires the identification of the producer's costs, which is a complex and time-consuming operation, especially in case of a collective dominant position where the firms to be examined are more than just one. Additionally, should the calculation of the dominant firm's production costs be possible, this may not be a credible benchmark for assessing whether there is price gouging or not. Firms holding a dominant market position are not necessarily cost efficient, and this is particularly true in our case, where we are dealing with firms that are not necessarily big businesses, and they are not individually dominant in the market. Hence, in case of firms which are not efficient, the production costs may be abnormally high. The European Court of Justice recognized that difficulty in the second case. Another major difficulty in assessing whether a price actually charged is excessive or not is the level of profit margin that should be acceptable. The comparison between the price and the cost is carried out to reveal the profit margin achieved by the dominant firm. Thus, the profit margin is the maximum fair price above which the price charged by dominant firms is excessive. Yet the European Commission and the European Court of Justice have not set a threshold above which profits become excessive. Profit margins vary widely across industries. What may seem excessive profit in static industries, where firms win or preserve market share by slightly undercutting their competitors, may be justified in dynamic industries where profit margins are usually much more significant because such industries are characterized by heavy and risky investments. The third practical hurdle that the European Commission and the national competition authorities may face is the application of the tests to analyze excessive pricing and see whether the price imposed is either unfair in itself or when compared to the prices of competing products or prices across markets. In order to achieve a robust result that minimizes errors, national competition authorities in Europe usually apply multiple benchmarks in parallel. So they will try to investigate the production costs, the profit margins, the prices of other firms operating in a different geographic market, and they may even make comparisons over time to determine whether a price is unfair or not. In the latter case, meaning when we use the historical benchmark, the common thread to all European cases so far has been that prices should exceed costs by more than 100%. Otherwise, the prices are not deemed to be excessive. So, as you can easily understand, in times of crisis and urgency, it is not easy and practical to examine so many factors and analyze all this data in relation to more than one thing. Particularly when it comes to the geographical benchmark that compares the prices of the collectively dominant firms with those of other firms in a different geographic market, there may be procedural hurdles as well. Everywhere in Europe, the prices of products in high demand are increased due to the pandemic. It is possible for the firms that charge higher prices to justify the price difference by reference to objective dissimilarities between the situation in the member states concerned and the situation prevailing in all the other member states. So, in case the national competition authorities go over all the above hurdles, the primary remedy that they have at their disposal is the imposition of interim measures in order to avoid market developments that enforcers cannot easily remedy at a later stage. Interim measures require only a prima facie finding of an infringement of competition law. This means that it is sufficient for the European Commission to prove that there is exploitative excessive pricing at first sight, or that its conclusions about the excessive pricing at first sight are not wrong. Yet, even a prima facie finding of infringement is not easy when the price gouging is genuinely unilateral and not collusive due to an abnormal level of demand. Where there is an oligopoly and the firms proceed to tacit coordination regarding the prices they charge, which falls short of an agreement or concerted practice, usually the European Commission avoids the condemnation of their parallel behavior as abusive, because in principle, the Commission does not want to act as a price regulator. Moreover, the threshold for defending the adoption of interim measures against application for suspension is still high, and as a result, the interim measure procedure can take on average 3 to 8 months. Hence, it is not an exaggeration to say that the procedural requirements for the adoption of interim measures outweigh the prima facie condition. Another difficulty regarding interim measures is that we have only little insights how they apply and which is the exact scope of the prima facie condition. And this is because the European Commission has made rare use of this remedy. Last but not least, it may be difficult to prove that there is urgent need for interim measures due to the risk of serious and irreparable harm to competition. And this is because in case of price gouging, the market developments are reversible in the sense that a prohibition or a commitment decision may be able to reverse the harm and make the firms reset prices to a non-excessive level. Imposition of fines is another remedy that national competition authorities have at their disposal. However, fines do not ensure that firms will comply with the decisions of national competition authorities and will not raise their prices again in the future. Fines are just a behavioral remedy, and the monitoring of their effectiveness may absorb many of the national competition authorities' resources. This is why it can be said that in this case, fines suppress the symptoms but not cure the disease. Apart from fines, national competition authorities can also rely on other remedies, such as encouragement of consumers to switch to less expensive offers of new entrants and removal of entry barriers. Yet, it is not easy to rely on these two remedies in times of COVID-19. They require new market players and plenty of time and resources on the part of national competition authorities to take the relevant measures. Coronavirus, as we all know, has a chilling effect on investments, and so it reduces new entries to the markets. Structural measures, such as the removal or prohibition of entry barriers to the market, require prior investigation by the National Competition Authority about the causes of excessive pricing. This kind of investigation needs time and resources, which means that the national competition authorities cannot take urgent action and apply promptly the relevant remedies. Besides, free entry does not eliminate by itself the power of incumbent firms in the market. Someone could easily say that excessive price cases are among the most difficult and complex cases for national competition authorities in terms of the design and implementation of suitable remedies. Therefore, it is worth examining alternatives to the available remedies. At EU level, a good alternative to fines could be the issuance of commitment decisions by the European Commission. Commitment decisions motivate the relevant firms to set lower prices in the future and offer conditions that are more convenient for consumers. The European Commission can issue commitment decisions instead of formal prohibition decisions when the companies under investigation prefer to offer binding commitments in order to remove the European Commission's competition concerns as they are expressed in a preliminary assessment. The advantage of commitment decision is that they can restore undistorted conditions of competition in the markets in a very swift and effective manner, as the relevant administrative process is really short. Commitment decisions can be either behavioral or structural and can be limited in time. This means that the European Commission is able to reassess them if a material change takes place in the meantime. They do not establish an infringement, and they do not require from companies to admit that they infringe the law. They only require commitment to future behavior. This is an incentive for firms to pursue the commitment route, as they know very well that in this way they avoid any damage to their reputation, as well as a formal finding of an infringement against them. If a firm does not comply with the commitment decision, the European Commission is able to impose a fine up to 10% of the firm's annual turnover without having to prove any violation of the competition rules. And now, given the aforementioned difficulties that the national competition authorities and the European Commission may encounter in excessive pricing cases, competition law enforcement may be a risky and time-consuming form of intervention, some people may say. So for this reason, it would be appropriate to discuss price regulation as well as an alternative to excessive pricing litigation. And this is the last part of my presentation. Price regulation can determine and impose controls on firms or industries in order to restrict independent price setting. This may involve a fixed price or rate of return, a maximum price ceiling, or minimum price floor. However, price controls and price caps may be in tension with competition policy. And this is because the free formation of prices is essential to the effective functioning of competitive markets and the efficient allocation of society's resources. Prices make consumers assess the value a product holds for them. Within the EU, there are also concerns that applying price controls contradicts the pursuit of a competitive internal market. The internal market is built on open and undistorted competition, which presupposes the avoidance of unnecessary public restraints that may affect efficiency or integration. Moreover, it can be complex and difficult to determine a regulated price. The regulator has to preserve, on the one hand, incentives for firms to operate efficiently, and on the other hand, to ensure that excessive profits are avoided. At the same time, the firm's viability as profit-making entities must continue. Despite the drawbacks of price regulation, the free formation of prices may not always guarantee socially desirable outcomes. For instance, in the exceptional case of emergency needs, firms may set excessive prices for necessary goods essential to consumers' continued health. In case of COVID-19, face masks have been an explicit example. Additionally, where excessive prices are unlikely to disappear, or this is unlikely to occur within a reasonable time frame, the likelihood that consumers will suffer high prices for a long time makes regulation necessary. Excessive pricing is self-correcting when high prices encourage an increase in supply by attracting new entrants to the market or encourage existing firms to increase their output. In a global crisis like the coronavirus outbreak, firms' ability to enter the market or expand production may be affected as the necessary finance for expansion becomes harder to secure as a result of the severe economic turmoil. So in the absence of self-correcting excessive pricings, the pragmatism may call for price regulation. In any case, whether because the interaction with the competition authorities or because of uncertainty around enforcement of the regulations, many firms have already committed to halt prices increases, especially after the first lockdown was lifted. So that was my presentation. Thank you so much for your attention.
Thank you very much, Penelope, for a very interesting and informative presentation. It was very nice to see all the kind of remedies you can use to fight this difficult thing about excessive prices. So let's now have the word of Commissioner Barreto.
So thanks, Vinícius. Good evening, everyone. So let me start by thanking the organizers for the invitation. And let me say that, well, I have selected 7 topics to talk today, and they reflect my personal view on the main struggles we faced at CADE during this year. All of them related to the pandemic, of course. So first thing was a struggle to remain in full operation. So let me briefly mention about that. CADE was one of the first government institutions in Brazil to have all proceedings in digital format. That started back in 2015. So when the pandemic began, we didn't have problems in quickly implementing remote work and homework for most of our employees. There are a few of them whose jobs couldn't be carried out remotely, and those continue to work in person. For those, we have published a guide for instruction and prevention of COVID-19. That's the name, and we have adopted safeguard measures such as distancing, face masks, sanitizers, employees' temperature checks, and extra cleaning. So those are like small things that we have to do to adapt in the beginning of the pandemic, and it was quite easy and quickly to do it, especially because of the fact that we have all documents in digital format, and then it's quite okay to work from home. Second thing we didn't have to change was we had to make changes in sessions. So there was an amendment on CADE's statute in order to allow judgment sessions to be carried out electronically, and that is started on April with live transmissions both at the CADE's webpage and YouTube. It's nice to briefly describe how the electronic sessions or virtual sessions happen. So all participants can interact in real time whenever necessary. For oral statements, parts were required to send a media file in advance. This is to avoid interruptions caused by internet connection problems. So it's also a way to guarantee that all parts have the same treatment. Nonetheless, if a part wants to intervene during the session in real time, it could do it through a virtual platform. So they're going to request, and session will be interrupted, and the party will talk, and so on. So those are basically the measures that assured parts could participate in the sessions, and all prerogatives of a non-virtual session were basically remained valid during the virtual session. So those first 2 points were related to like day-to-day procedures to keep working on during the pandemic, and I believe CADE has successfully being able to fully operate during this period. Third topic I select to talk was provisional changes on the competition framework. There was a law that was basically passed this year with the beginning of the pandemic, and withdraw the effectiveness of some provisions of the Brazilian law competition. during the state of public emergency that will finish on December the 31st. So during this period, it will not be considered an economic illegality to sell goods or provide services below price cost, or to seize companies' activities without reasonable justification. Moreover, companies that intend to do associative contracts or joint ventures are not required to submit the transaction to CADE during the state of public emergency. However, all the transactions are subject to further assessment, and including investigations of anti-competitive practice of those agreements. And in particularly, the law explicitly says that the agreements are justifiable if they are really necessary to mitigate problems caused by the pandemic. So you cannot do like opportunistic behavior and avoid the jurisdiction using the pandemic as an excuse. So those are like the main changes on the legal part of the antitrust in Brazil. Fourth point that I would stress is on right to petition. So let me explain that. So despite the provisions that I have just mentioned, the legal provisions, many enterprises have approached CADE formally and informally to discuss those short-term arrangements among them, all of them related to difficulties caused by the pandemic. Formally, we do have we do have the consultation as a formal way for firms to approach the authority and basically ask whether some agreement or some practice is competitive or anti-competitive. But I mean, the consultation has like some formal steps, and it usually takes a little bit longer than what was required during the pandemic. So during the pandemic, we have allowed a weaker way of consultation that we based on the right to petition, in which firms make a petition making questions about whether this arrangement is okay or not okay from the antitrust perspective, and the antitrust try to review it in very few days, sometimes less than a week, and this was not binding in the sense that doesn't oblige any of the parts regarding future investigations or etc. But it is, let's say, a formal position of the institution, which makes firms more comfortable in going ahead with their plans. On that regard, we wrote a note concerning collaboration about competitors during the COVID crisis. And this is a document that provides guidance and parameters for the elaboration of those strategies to fight the pandemic and other economic problems that the firms were facing. The general guidelines involve essentially considerations about scope, duration, extension, governance, transparency, good faith. So basically, general principles that firms should have in mind when doing joint arrangements to fight the crisis. It's important to stress this sort of agreement is only accepted as a temporary measure, and companies were required to demonstrate the impact of the pandemic on its activities. I mean, we have also recommended all firms to take measures to prevent anti-competitive practices such as price fixing, market division, supply restriction, exchange of sensitive competitive information, and at the risk of being investigated later for those practices. So this is another procedural change that we made during the crisis to speed up our analysis of something that is similar to a consultation, but it's weaker than a consultation. And again, as I said, it was based on the right to petition. Fifth point. I'm going quite on time, I guess. Standard for merger reviews. So we basically make an effort to keep our standards for merger review. From March to October, we have decided 344 transactions in a time frame very similar to those before the crisis. So it's a lot of transactions. And that were basically not affected during the crisis, in the sense that we kept the standards and we kept the speed. We do expect, or we are preparing ourselves for increasing the number of mergers and acquisitions after the crisis, because companies in bad financial situation might be targeted by other companies, and we will do all the effort necessary to make quick reviews, effective responses, and I mean, try to work as sharp as possible. But with that in mind, we are not lowering standards for merging review. Sixth point I selected was related to what Penelope has talked. We did receive a lot of complaints about price gouging, especially on health products. So let me say a few words about this. So in the very beginning of the pandemic, hospitals related price gouging on health products, and as in many other countries, an arbitrary increase in profits is not legal according to the Brazilian competition law. So what CADE did was it initiated a preparatory procedure to investigate whether companies in the healthcare sector, those that produce alcohol gel, for instance, or masks, sanitizers. I mean, we are doing investigating whether they have raised prices and profit in an abusive way. This investigation is being conducted by the CADE General Superintendents, and it's ongoing. Seventh, and perhaps most an important thing that we have been doing during this year is like we have been much more involved in advocacy. Because there were a lot of bills being proposed in Congress and other governments. And CADE has issued several technical reports related to the pandemic concerning legislative proposals. Let me mention 4. So first one is concerns the healthcare industry. So CADE was formally asked to provide an opinion regarding 2 bills under discussion in the Brazilian Congress, which proposed price freezing and price imposition to products considered essential to fight the pandemic, such as medicines, masks, hand sanitizers. It was interesting to hear from Penelope that something similar happened in France. Except that in France it happened, in Brazil it didn't. In Brazil, we basically issued a report to the. We answered these 2 formal requests and have made a position very clear against price freezing at the pandemic. And I'll be back to this point in a minute and try to relate to what Penelope said. Second thing, so the first one was healthcare industry. Second one was what we call the cooking gas, liquefied petroleum gas. There was a similar discussion about imposing price ceiling for cooking gas. I will comment on that too. I will comment on all policies, all advocacy we made together. The third sector that was affected was educational sector. So there was discussions about imposing uniform discounts on educational services once they have moved it online. And finally, there was a bill under discussion that intended to regulate fees charged by apps such as Uber and Cabify, transportation apps. We again have issued a report on that topic. If you take out the 4 sectors, what they have in common, they're all different sources of price regulation. So that's why I decided to talk about the 4 together. I mean, the CADE's point of view is very clear about this. I mean, price control may generate losses for resellers. It punishes companies that are subject to more intense competition. It may cause increasing market concentration due to either bankruptcy or temporary closing. Price control usually causes product shortage. People stop producing, storage, and to sell it later when the price goes up. We have seen that many times in the past when we try to control inflation with price freezes. So for all those reasons, we basically believe that those policies, although well-intentioned, they were not good from the competition perspective. In case of education, it's quite nice because many politicians were saying, well, since kids are at home, why do parents have to pay bills? And well, private schools basically moved fastly to online classes. And moving online is not cheap. I mean, it's a whole sort of adaptation that must be done to do that. So if I would say that if we had implemented price control on the education, we would probably not have moved to online courses as easily as it was done in most private schools. So again, this is a type of shortage that derives from price controls. And in all the 4 sectors that I mentioned, I believe there was similar risks. If you take, for instance, and Vinícius, you please interrupt me if I'm taking too long, but I think I still have
you have like
minutes.
More 10
Okay.
minutes, 50 minutes too.
I don't think I have 10 minutes of things to say, but I mean, I do need a few more. So the thing is, I was saying that price controls may cause many competition problems. And if you try to remember on the beginning of the crisis, there was basically it was very hard to find a mask the first few weeks. Because a lot of people bought it, hospitals bought it, and basically if you try to buy, you probably would pay a quite high price. But a few weeks later, you basically could see masks everywhere, including on the street. I mean, people selling masks on the street, on the internet, everywhere, literally. And well, at least around here, it costs less than 10 reais, which is nowadays $2. So this is an example when you might, an increase on them, a short-term increase in demand might increase prices in the first moment. But if the supply side is competitive, it will react and will take advantage of the high prices and will increase the products that are being demanded. So price is a way to communicate consumer wishes and firms willing to provide those wishes. So if suddenly everyone wants masks, well, of course, there won't be masks immediately. But if the supply side, the system of supply is okay, is reasonably high, when price increases, supply will increase. And that is the beauty of the price system. So we should be very careful when we control that system, because we're basically controlling a communication system between supply and demand. And we do have to be worried about price gouging. Penelope was saying that price gouging in time of crisis is sometimes practiced by firms that has no market power in the sense of having very low market shares. But I missed my point. So I was saying that yes, firms that have low market share sometimes do practice price gouging because they might be locally, they might have local market power, especially for immediate supply of products, due to the fact that they have storage some products or they have some local monopoly power or market power. And for those reasons, we sometimes see things such as masks and alcohol having a huge increase in prices. And those are not things that are produced by one factory. It's basically many producers all over the country. Nonetheless, in the short run, we did see price increases, but that is a sort of problem very different from price gouging on essential facilities or things like that, which supply side cannot react at a reasonable time. So for the cases I have discussed it before, I believe there's no room for government intervention, and happily that's what happened in Brazil. We didn't impose any type of price ceiling, price caps, or price controls in general. So to conclude, I I would say I believe, but I believe everyone in CADE believes the same. So I would say CADE believes that the best way to face the pandemic is through more competition, not less. The current situation required a great deal of adapting and innovation from CADE's perspective, and we have done that based on the premise that of promoting competitive environment as intense and as healthy and as promptly as possible. That's it.
Thank you very much, Commissioner Barreto. You showed us in a very clear way the CADE's attitude in front of the crisis and in response to the crisis of COVID. So now I'm going to pass the word to our debaters, starting with Maria Fernanda. So, Maria Fernanda, the word is yours.
Thank you, Vinícius. First, let me join my colleagues in congratulating IBCI for this nice event, very interesting, informative. Thank you for the invitation, Vinícius. Thank you, Penelope and Commissioner Barreto, on the very interesting presentations that I've learned a lot from it. I guess I will divide my debate in two main parts. First, I have read the paper from Penelope, and I think I have some, and also listening to the presentation, I have some points to raise in the debate that now, also listening to the commissioner's presentation, I guess my debate will be to both of them. And afterwards, I have another few comments on specifically on the commissioner's presentation. So regarding Penelope's presentation, which is on excessive pricing, I don't have too much time, so I will focus on two topics for debate. First, thinking about excessive pricing and this what she called transitory market power, which was also a term used by the European courts. I want to discuss the role of antitrust authority when thinking about short-run versus long-run effect in competition. I guess this is something that it was raised already by Commissioner Barreto, but if we think about neoclassical microeconomic model, if a firm is profiting, then it will encourage more firms to enter the market. And in the long run, there will be competition and there will be a zero economic profit condition, which does not mean that the company does not have profit, but the company does not have an economic profit. And then Penelope explained very well in her paper that this entry movement is harmed in the context of the pandemic or in the context of an economic crisis, that this entry that is expected in the market from these neoclassical macroeconomic models is harmed. But I have to say that it's not zero, because in practice, we see that it was a matter of months indeed to have more products available in the market. So not only a complete new company entered the market, but also the established companies incubating other products, similar products than hand sanitizers or facial masks. They changed a bit their production plant in order with lower costs to provide products. So they adapt their production plant and also start providing these hand sanitizers, masks with a lower price. So what I want to hear the opinion of both of you is whether how to prioritize, the competition authority should prioritize this look on short-term effects, on long-term effects, or both, or what do you think about it? Because if we see what happened in Europe and all these procedures starting in the national competition authorities about excessive pricing, it shows a concern about the short-term effects. But what we see in practice is that it was a matter of months that the prices and the level of products started to go up again in the market. So this is my first point of debate about this, the importance of checking long-term versus short-term effects. The second point that I decided to choose is regarding the price regulation, because of course it's a very controversial and political discussion. It was also very interesting to hear from Commissioner Barreto that the position of CADE in this sense on not voting, let's say, for a more intervenient price regulation, but a more laissez-faire approach. I will again bring an economic theory that was already discussed in the beginning of the panel, that of course price ceilings, price floor, they bring inefficiencies to market. It was mentioned already, possibility of shortage of products. So my question is, how, that I put also in the debate, how to balance this necessity of taking care of the price for essential elements in the context of COVID, and the goal of competition law, because regulating price might be optimal strategy if the goal is price control or consumer protection in a more sense of guaranteeing a low price to consumers. But if the goal is economic efficiency, then regulating price is not optimal. So from what I've heard from the commissioner, CADE had a position as if the goal of competition law in Brazil would be economic efficiency. And then indeed, the price regulation would not make so much sense. I'm not sure if you put in, I'm trying to raise points of debate. And Penelope also mentioned the problem of putting price caps in Europe because of the goal of competition law in Europe being the respect on the internal market. So I want to hear from you these discussions on the goal of competition law and the role of price regulation, both in the experience in Europe that Penelope brought. I don't know if this was something that the decisions that you have been touched, or this discussions on excessive pricing in Europe brings the discussions of the goal of competition law, and also from the commissioner regard if CADE used the justification of the goal of competition law to justify these efficiency claims. And I just want to say that having the goal of competition law clarified is easy. If the authority has, then it's easier to tackle, I guess, the priorities of the competition authority during the current pandemic. Otherwise, there is always the risk of other interests to prevail. And so these are the two main points regarding the excessive pricing aspects that I wanted to raise. And finally, regarding CADE's achievement, first I want to congratulate the authority for all the efforts to maintain a great level of enforcement during the pandemic. And also I have been following what the authority has been doing, and I know that you are trying to keep a lot of efforts to maintain also the guidelines and the suggestions from ICN, OECD. It has been a very impressive job. I will raise one point that it's also something that I'm very interested at, also because it's part of the PhD I wrote. It's about cooperation among companies. And what I want to ask for Commissioner Barreto is, how would CADE handle at this, let's sort of ex-post assessment of contracts that are created in the context of this pandemic? As you mentioned, there are some, so CADE published guidelines, let's say, to, or this note to help business people to assess what kind of contracts they can or cannot engage, let's say. But there would be also worrisome from CADE on guarantee that potential abuses would be, there would be an ex-post enforcement of this case. So it's out of curiosity, but also I think it's a very nice point to debate. It's how CADE would handle this ex-post enforcement. What are the tools that the authority is thinking about increasing the legal certainty to business in general? And this I'm saying because since it is expected more commercial collaboration, also vertical agreements, then it is kind of, just because it is expected more in the context of after economic crisis, it's also expected more restraints as well. So the more vertical agreements, somehow the more vertical restraints you can also expect. So that's why I'm curious to learn about this ex-post assessment. And just a general topic, what are the lessons that CADE has learned with the pandemic? In general, I think it's also always interesting to hear. So I guess these are my points. Thank you again, Vinícius, for inviting me, and I look forward to hearing the reaction of my colleagues.
Thank you very much, Maria Fernanda. I don't know if Estevez wants to speak here now, and then they react to both discussions. I think maybe it's better.
I think so. Hi, thank you so much for. Thank you a lot. No problem at all. Thank you so much. It's a pleasure to be here. I would like to, a very nice panel to discuss this important issue related to pandemics and competition law. Basically, I will try to talking about three different points that I consider is basically, in my opinion, the most important points. The first one is basically a question that what do pandemics do in terms of market concentration? Fortunately, pandemics are not a regular kind of event for us, so good for us. So we don't have a lot of empirical evidence to talking about or to try to make any kind of evidence about that because, of course, the evidence is not so huge. But for example, when we try to look at the literature, we can, for example, the Black Death in Europe in the late of the Middle Age, responsible for a lot of deaths, basically more than 25 million people die in that situation. And it's possible to try to use these economic implications to make any kind of inference about market concentration. Basically, the economic implications of Black Death were sharp decline of the labor force, of course, in agriculture sector, sharp decline in economic activity, agriculture, crops, and so on, trading, and the huge destruction of wealth, asset values, including this kind of asset values or the amount of asset values serving as collateral for banks in that situation. And of course, we had a sharp increase in of bank credit default. So it implies an important and a remarkable example of market concentration after pandemics about the banking sector. In that situation, thousands of banks broken in European different countries. In that situation, not countries, but across Europe. We have a lot of thousands of banks. In that situation, the bank systems is basically a proto systems with very small banks, family banks, basically providing small loans for local people and so on. After that, after this huge idiosyncratic shock, we had incumbents and survivor banks that capture market share left by failing banks and built large-scale, big scope financial institutions with different kinds of business in European markets, in different European markets. It was basically the emergence of banchi grossi, the large banks, a new structure of bank systems with huge institutions, financial institutions, large scale, big scope, a lot of products and assets and sophisticated methods to manage liabilities and assets. And the remarkable example is La Banca di Medici di Firenze, the bank of family of Medici for Florence, La Banca Monte dei Paschi di Siena. Until today, nowadays, we have this La Banca Monte Paschi, the older bank of the world. So very huge institutions. So this experience basically showed that in the absence of public policies like fiscal policy, monetary policy, regulation, competition policy, we can expect that this kind of unanticipated adverse shocks implies in market concentrations. In some examples, like for instance, huge concentration. But nowadays we have a lot of policies, public policies that try to manage or to mitigate the effects of ex post effects of the pandemics in market concentration. But when we have a trend to market concentration and we have a lot of policies try to mitigate the market concentration. On the other hand, of course, it can serve with a kind of a trigger for hidden concentration. And it's my second point, it's about cartels, pandemics and cartels. It's important to take into account that when we're talking about, for example, business cycles in the economic activity, we know that the cartels, the stability of cartels or the creation of cartels tends to be different trends along the business cycles. But the fact is that pandemic is not exactly a kind of business cycles because it's not a regular kind of variability, volatility of the activity of economics. It's not exactly a 2 standard deviation, 3 standard deviation shock. It's a 10, 12 standard deviation from the average of expected values of growth, market returns, risk, and so on. So, so we have 2 different incentives when we have for cartel stability or cartel formation when we take to account these kind of huge shocks. Incentives for cartel cooperation, of course, it serves as a cartel trigger for cooperation in cartels to avoid squeezing profit margin motivated by decline in demand, for example. But on the other hand, we have also incentives to cartel defection because it's not easy to manage cartels, in fact, because market forces tend to create a stable equilibrium. Stable equilibrium, market force, demand on the supply, push and pull forces in order to stable equilibrium. So shocks tends, of course, to create some volatility, but the markets accommodate the situation. But cartels is not, of course, there is kind of equilibrium in cartels, but not exactly stable equilibrium, but unstable equilibrium because market forces don't provide this stability. So this stability has to be generated by management of cartels. It's not easy to manage cartels. And the fact cartels may be a very profitable thing. and huge shocks tended to change structures of parameters of demand, of supply, and it's easy to detect cartels, missing information, and so on. So we have two different effects, two different incentives to mark cartel stability. But few evidence shows that the formation for cartels tended to create a net effect in order to provide it to stability cartels. Another point related to cartels and related to very huge shocks is basically, as I just mentioned before, it tends to create structural changes, basically structural breaks. So it's important because the information from the past in this kind of situation is no more a good source of information to estimate anything for the future. It's complicated because it's not easy, for example, to estimate cartel damage, because the counterfactual competitive price market, it's not possible to infer. The same thing is very difficult to use screening tests, statistical screening tests to detect cartels. For example, it's used in the by CADE in the Cerebro project. So my last point is related to guidelines, antitrust, competition policy guidelines, and the pandemics. Competition policy around the world is guided by protocols and best practices, and it's reflected in published and antitrust guidelines and handbooks. Every good antitrust authority uses guidelines in order to how can I say, to improve the procedures in order to analyze mergers and acquisitions and so on. The problem, and I have some experience because I was chief economist of CADE for 2.5 years, and I was responsible to organize the works to write the new merger guidelines of the authority. And I have some experience, and it's an important point because in my opinion, in general, guidelines works like contracts. The problem is that they are not complete, and it's not possible to take into account every contingent situation. So we, in guidelines, in general, we use it to the most often well-known and benchmark screening tests, simulations, and guides for analyze mergers, acquisitions, and so on. But we think about models in order to write guidelines. For example, Nash-Cournot equilibrium model, Bertrand equilibrium model, game theory, prisoner dilemma, Folke theorem, and we think about models and equilibria. Of course, we take into account variability, we take into account some situations with high volatility, business cycles. Of course, it's not possible to think about a perfect world, but this kind of event like pandemics or very huge financial crisis, I don't know if we can deal with this kind of situations with the toolkit of instruments that we have in guidelines. So, like for example, this is a black swan shocks, high improbable events. To be very frank, nobody think about that when writing a guideline. And when we have this kind of situation, I don't know, to be very frank, I don't know if guidelines are suitable for deal with this kind of a situation. I'm not sure about that. And the experience of other sectors or other regulators, for example, after the financial crisis in 2008, banks, regulators had to create new tools in order to improve the toolkit of that authority. And I don't know if it's a case of competition policy and antitrust authorities. To be very frank, I don't know if this kind of guidelines are more suitable toolkit to deal with this kind of very extreme pandemic situations. Is that? Thank you so much. It's a pleasure to share with you this discussion.
Thank you very much, Professor Estevez. And now we can have the word from Penelope and Commissioner Barreto. I don't know who wants to speak first. Can be Penelope.
I would be happy to take the floor first and deal with the very, very interesting points of Maria Fernanda. Thank you so much for giving me the opportunity to say a few more words about the prioritization, as you said, of the short-term and long-term effects, and how to balance these, the necessity of regulating prices and the call of competition law. Well, we all know that on the one hand, high prices in the long run boost firm supplies, but in the short run, these high prices may cause problems, especially when it comes to the supply of health workers with essential hygiene products in heavily affected countries like Italy and rather other European countries. So this is a problem indeed. So what I've seen happening in the United Kingdom, where I live and work, is that the Competition Market Authority has tried to take moderate measures in order to deal with this situation. And this allows me to say that CMA, the Competition Market Authority, is a big fan of the long-term effects that COVID-19 may have. So they were not trapped by the urgent situation, trying to take hasty decisions in order to stop excessive pricing and trying to please consumers. But on the contrary, they took, as I said earlier, moderate measures, but at the same time, measures that could create the conditions, the circumstances for a better competitive environment in the near future. And let me be a bit more specific. First of all, CMA launched a COVID-19 task force, okay, to scrutinize market developments, to identify harmful sales practices, and last but not least, to warn firms suspected of exploiting the circumstances and people's vulnerability. So warning is the key word, in my opinion, because what the antitrust enforcers did in the UK was to make it apparent and absolutely clear to the firms that they will be punished and they will face serious fines and measures if they don't comply with the competition law provisions. I'm saying that because they have published open letters to many dominant firms in many sectors, like the pharmaceutical sector, the food and drinking sector, warning them that they should stop price gouging during the crisis. And they even started investigations against some of these firms. And though they found that there was a raise in the price of hand sanitizers around 400%, which is an obvious price gouging, they preferred to stop the investigations and drop the complaints simply because the firms complied with the warnings and they were afraid of the investigations that CMA initiated against these firms. Of course, this depends on the mentality and the philosophy of firms in each particular member state. Perhaps firms in another state, I don't know, like Greece, like Italy, wouldn't react in this way. Perhaps they would also comply, as the firms in the UK did. Another really important issue that I would like to talk about is that CMA published guidance according to which they gave clear guidelines to firms how they should cooperate during the crisis in order to be able to, as Maria Fernanda said, increase the production of their products and even start activities in other sectors of the same market by producing products similar to those that they used to produce. So this was something quite innovative, I would dare to say, because we all know that cooperation is not permitted due to 101 of the Treaty on the Functioning of the European Union. It may be supposed to be a cartel, an explicit, a coordinated, a concerted practice. However, the CMA fully understood the necessity of some firms to cooperate, otherwise they would go bust or go outside the market, and that would be a disaster, a financial disaster for the whole country, for the whole nation. So they preferred to give clear guidelines to those potential cooperators rather than condemning prima facie their attempts to cooperate in their attempt to survive financially COVID-19 crisis. Now, regarding price regulation, how to balance this necessity and the goal of competition law, France is and Cyprus as well, two countries in the European Union that dared to proceed to price regulation. Other than these two countries, no other countries, to my own knowledge, and please correct me if you know something that I don't know, no other European countries proceeded to price regulation. So I would dare to say that price regulation is a last resort for competition authorities. They prefer having undistorted competition and prices that can be self-corrected, as I mentioned in my presentation. And this was the case, fortunately, in Europe, thanks to these measures, the moderate measures that competition authorities like CMA took, meaning that they enabled firms to cooperate. They preferred having commitments on behalf of the firms that they would stop price hikes and they would lower their prices. So price regulation is a last resort. So I couldn't say that there is a dilemma as things stand between a price regulation or the goal of competition, which is, what is the goal of competition law actually? It has multiple goals, one of which may be the undistorted exercise of transactions of financial activities in order to achieve consumer welfare. So since consumer welfare is achieved, if consumers are not endangered, are not threatened by high prices, then there is no need for a price regulation. And this was finally achieved thanks to the really good coordination of people working in the CMA in the UK. And the same, I believe the same happened in many other European countries. I don't know if, Maria Fernanda, I have covered some of your points, if you would like to add something or...
No, it was all very clear. I know that the goals question is a bit tricky one, but yeah, thank you very much for the answers. I'm very happy to hear that.
Thank you for your really nice points. You made me think a bit more about my topic.
Nice, great.
Thank you. Commissioner Barreto, do you want to answer some of the.
Sure.
Okay.
Yes, let me start with Luis' points, and then I move to points that Fernanda made to me too. So Luis, correct me if I'm wrong, but I pointed here three different points that you raised. First, that adverse shocks tends to increase market concentration, and you mentioned the example of banks in the last financial crisis. Second point is that adverse shocks may lead to increasing the number of cartels, and that our current structure might not be well prepared to deal with that increase, because the idea of like structural changes in data that won't allow us to use the standard econometric procedures to attempt to identify cartels. And the third point, it's more like a provocative question, whether the current toolkit to deal with extreme situation is good or not. So let me start with that. I don't know. We will see as we move through. I do believe we will need some innovation to deal. But last year will be an interesting year to discuss this. Regarding the 2 points, the first 2 points. So yes, I do believe that adverse shocks has potential to increase market concentration. As you said, there are forces that move in that direction and forces that move in the opposite direction. But the main force that I keep in mind is that firms under struggle financial situation, they tend to be targeted by other firms, and I do think there going to be a wave of increasing in the number of mergers, and then a consequence on the number of the amount of concentration in the market. Well, while this is part of life and we have to deal with it, I would say that we have to deal with it in the using the standard methods and trying to avoid as much as possible the increase in concentration, being aware that this is cyclical, sometimes happens in some sectors, and we wish that things will return later when things come back to normality and new firms enter. Sort of important thing to be paying attention now, in my view. So sectors that entry barriers in the long run are not too big, I wouldn't be too much concerned. Others, I would be much more concerned. So if you have to choose, I think this is one thing to be paying attention. Regarding your second point, well, yes, there is a problem in using historical data to identify price anomalies that would said was like the process that used in CADE to access this type of data. It might have noticed the problem will be more related to over-identification than under-identification. So it's more likely that the computer will point out a lot of prices that are strange, and some of them are due to cartels, and all others are basically due to demand shift, which are not related to cartels. So we might have to have more investigations that will lead to nothing in order to cover all possible cases. I think this is pretty much. Do you want to comment?
No, because I think the internet is it's you freeze it sometimes, but it's okay. I think you could understand.
Yes, I think it's correct. I agree with. And in fact, my last point was more complicated, but I agree with. Okay.
So I have a question from the audience. I'm gonna ask, and the question is for Commissioner.
I would like to add there's a few points that Maria.
Sorry, Commissioner Barreto, you can speak.
If you wanna pose the question, but I will come back because
no, you can go. Sorry.
That I would like to. So very quickly, again, Maria, I have also very interesting point about entry. Is it entry hard during the pandemic, and would that cause supply side not to react to a price increase? So I'll just remind you two things. One is like you have this type of increase in supply due to entry. So but you also have the intensive margin. The same firms producing more at a higher cost. So the new equilibrium price will be higher, but I mean, it won't be high in the sky. It'll be just proportional to higher marginal costs. So as far as competition is working, I mean, even if there is not fast entry in the market, there is still reaction in the supply side. And regarding the products we're discussing, such as masks and sanitizers, well, it was quite easy to enter, quite fast. A lot of people that are doing nothing start to build masks, and a lot of firms would able to produce sanitizers, and it's a temporary entry. I don't think they're going to remain doing that forever, but I mean, during the crisis, they're doing that. That's what's left to do. And so the supply side has this two forces that are entry and increase in the intensive margins that helps to return to normality as quick as possible, depending on the sectors. Second point to raise is you mentioned price regulation. So you mentioned that price regulation might be good for consumers, but not good for efficiency. I totally agree that it's not good for efficiency. I don't exactly agree that it's good for consumers, because even if you reduce prices in the short run, consumers may face higher prices in the future because of increasing market concentration due to bankruptcy and firms' problems, financial problems. And even in the short run, there might be shortage of products. So, I mean, I do love to pay little for masks, but I mean, if there is no mask, I'd rather pay a little bit more and have one mask. And so it's not clear that all consumers benefit from that. Of course, those that are able to buy the product, they're fine. But those that are left without anything, they would probably be better if they paid a little bit more and had something. And finally, you asked about cooperation among competitors and how can we deal with abuses. So I have something about that on my talk. Let me try to provide guidance on the elaboration of strategies to fight the pandemic, right? We have only accepted short-term agreements and temporary measures that are related to the pandemic, and firms were requested to demonstrate it, and they are awarded that they were warned that they must pursue pro-competitive measures to avoid price fixing, market division, supply restriction, exchange of sensitive information. So there was a lot of recommendation on this side, and they face the risk of being investigated and punished later if they do not comply. So this is what I believe the essential position we made. You mentioned we're doing something like laissez-faire, and I said, well, it's a little bit less that we keep the investigation power. So if things do not work fine, I mean, we will act. But I mean, it's not totally laissez-faire. That's the only point. Sorry, Vinícius, I just wanted to. Questions were very provocative and nice. Thanks for both Madi and Luiz.
No, thank you very much, Commissioner Barreto. Sorry, I was just because sometimes the internet, I think you freeze it, but you could understand, and it was a very nice explanation and a very nice answer. I just want to ask one thing about the audience, maybe one thing about me, for both of you, for you and for Penelope. So one question from the audience is like this. Some competition authorities, as CADE, they use it to some special standards for approving mergers. They made like sometimes a fast track for some approvals, but the question is this: do you plan to have another review or another merger review or another collaborations review after the pandemic is over? Because when you made this first and maybe more fast analysis, you had less information, you are in the middle of the pandemic, and could you think it's worth it, or do you plan to do another review of these things? And my question, like the collaboration, I think could have some standards to say that, and the CADE guidelines or note about that said some of the usual standards, but do you know can you say about any restraint CADE imposed or another competition agent that imposed to approve a collaboration in the pandemic, one that you think is worth it and can have a potential to make the collaboration good for the pandemic, but also good for the long term?
Should I start or?
Yes, you can start in Penelope.
Okay, so quickly before I forget the 2 points you rose. So first is because I didn't have time to write. So the first one was
if you plan to do another review after.
To do another review?
Yes, another review from some of the cases you approved during the pandemic, where you have more information.
So yes. So I think I was misunderstood, because there's no approval of mergers during the pandemic that followed any different procedure. So there was no rush to approve mergers at all. So what we did rush was to give firms answers about whether this practice is competitive or not. So there is a new procedure on this, less bureaucratic, also less enforceable. I mean, it's much weaker than a consultation, but it still works to provide some stability to firms to go ahead and not worry about being investigated later. But regarding mergers and acquisitions, I think there was no change in the standard at all. I mean, what I said is that we have kept the same timing, which is basically something important during the pandemic, because everybody was working from home, and investigation is much more difficult. I mean, just some questions to firms that they take much longer to respond because they are basically closed and nobody's working there. So the fact that we have kept the productivity, I think it's quite remarkable because of those difficulties. But that's the only thing I was pointing out. We didn't rush on mergers and acquisitions. And I forgot our second question. I'm sorry. I'm too old. If I don't write, I forget.
Oh, sorry. It's about the collaborations.
Yes. There were not many. I just remember one, to be honest, one between the beverage industry.
The Movimento Nós.
Exactly. Remember that one. And there, the main concern were that firms shouldn't divide the market, shouldn't share information, shouldn't impose restrictions on establishment, on retailers, just sell just the products of those that are incorporated under that initiative. Those were to the core, and those have been the two firms, not true.
Okay. Thank you very much, Commissioner Barreto. So, Penelope, do you want
Yes, a last point about the measures.
Does that answer?
Sorry, Commissioner. But you freeze it, so it's hard for me. Do you want to speak more? No. So, Penelope, I think you can speak. I don't know.
So, when I was my net.
I totally agree with what Commissioner said about the procedures that were followed in the mergers. We don't see something abnormal happening during the COVID-19. Perhaps, Professor Klein, you referred to the merger between Deliveroo and Amazon, which was a characteristic example of two giant, we would say, firms that were merged. Did you have this in your mind, or any other merger that?
No, it was like the idea of the question is like you have less information now. It can be measures or it can be like collaborations, and sometimes you can have like new information. And the pandemic is a very exceptional time. So if you want to review, or if you think it's worth reviewing some of the things you did during the pandemic.
What CMA, the Competition Markets Authority, did in the UK to deal with mergers during COVID-19 was to publish a disclaimer informing firms to delay merger notifications for the reasons that the Commissioner mentioned, because it's not easy remotely working to collect data, make the investigation. So this was a measure taken by CMA, delay of mergers notifications. And perhaps, since you're giving me this opportunity, perhaps we could see in the future the failing firm defense being invoked more frequently in the near future. And allow me to tell you my opinion that perhaps there should be some amendments in the legislation in the way that this defense is applied. It's the requirements are too strict sometimes, since we don't see many cases in which the failing firm defense is invoked. Perhaps we should start thinking of the possibility of accepting this defense more frequently in order to enable firms to merge and avoid exit from the market.
Okay. So I think we're done for the questions, and the time is almost over for our panel. So I'm going to ask you, each one of you, in like 1 minute, say a final comment to end our great conversation. I don't know, can you start, Penelope?
Sorry, I haven't quite understood what I'm supposed to do now to make a comment.
A final comment, just to end the panel. A final comment, just your final words.
I would thank the organizers if that helps.
Thank you.
No, Penelope, go ahead. I mean, I was just making fun. I mean, final comments basically. Thanks everyone for being here. Thanks for the question. Thanks Luiz. Thanks Maria. I mean, it's a very nice chance to interact. I did enjoy. It was good to be part of it.
Yeah. On my behalf as well, I would like to thank you all for the great organization.
Yeah, I would also like to thank both speakers for returning to my questions. It was just points of debate from what I thought that would be nice to raise, but I think you both did it very well. I'm very satisfied with the answers, and thank you for the opportunity to be here. It was very, very nice and interesting.
Thank you.
Professor Penelope?
No, it's. Do you want to say your final comments, Professor Estevez?
Yes, for sure. Thank you so much. I think that it's a great panel, a very good discussion. It's clear that we have some challenge for the next years. I suppose that the effects of some of the effects of the pandemic tends to be permanent. And of course, it's create a lot of demands, and we know about that. But I'm sure that we have a well-prepared antitrust authorities with well-prepared teams to deal with this kind of situations. And it's very clear for me that we do not lose welfare because this kind of problems. Thank you so much.
Thank you very much. Thank you all for this great conversation. And bye. Thank you very much.